Wait, please, yes, your lordship. Lordship, I beg to mention item 8. Lordship, can the matter kindly be adjourned?
Item 8,
Yes, lordship. It may come up after vacation. It may come up
after a vacation. You are
I'm AK Choppy, appearing on behalf of Mr.
AK?
M. AK Choppy.
Trophy.
Yes, lordship.
Give the name. Learned Counsel appearing for
Appearing on behalf of M. Biswas.
Mr. M. Biswas. Learned Counsel for the appellant. That the appeal be listed after 4 weeks. Ms. S.H. Vora. Learned additional public prosecutor. You have informed of private party.
No, lordship, we haven't informed.
You should have informed. Otherwise, they may wait. Liquid over any liquid over has no
May I plead your lordship? I beg to mention item number 1.
one. Okay.
My humble prayer is to kindly adjourn the matter for today and fix after vacation.
On the your name, please.
You know?
There is also amicus.
Yes, lordship.
Have you informed?
Inform course,
My senior is informed.
they can consent.
MS
Borguhai.
S. Baruhai. Your name
Barsha Borua.
Well, learned friend is appearing for the other side.
They are making prayer. Yes.
B. Borua.
B. Borua, Learned Counsel appearing for Mr. S. Baruhai, Learned Counsel for the appellants, has prayed for listing of the appeal after 4 weeks. As the prayer is not objected to by Ms. S.H. Bora, Learned Additional Public Prosecutor for the respond number 1, State of Assam, and Mr. M. Smith,
Phone number.
Learned amicus curiae for the respond number 2, comma, the prayer is allowed, there is the appeal after 4 weeks. On the date to be expired.
Your Honors.
Okay.
May I please, your lordship, I beg to mention item number 3, seek for adjournment.
Item number
3,
3.
yes.
3 is connected with 2.
3 is appeal against.
She is
acquittal.
against acquittal matter. I am for private respondent.
Okay.
I have no objection.
And who is there?
Niyormoni Reka.
Item number 2.
I
Yes.
am adhering for item 2.
It is
What is
appeal
your-
against
Ready
conviction.
for hearing.
But they are seeking an adjournment.
Honorable problem, if court allows, I have no objection.
Huh?
If honorable court allows, I have no objection.
Otherwise, 2 may continue, lordship. It is appeal against conviction. And so far as item number 3 is concerned, is the appeal against acquittal.
But
So-
arising out of the same judgment.
Same
Yes, sir. If your lordship pleases, then I may advance my argument.
So what is the purpose? If they are seeking adjournment arising out of the same judgment, it will be difficult. Yes. Ali Learned Counsel for the appellant in 2.
Next date after vacation.
MS,
And
your name,
my Momi Devi.
M. Devi, Learned Counsel, appearing on behalf of Ms. N.M. Deka, Learned Counsel for the appellant in 3. MS S.H. Bora, Learned Additional Public Prosecutor for the respondent number 1, State of Assam, in both the appeals, and Mr. C. Goswami, Learned Counsel for the respondent number 2, 3, and 4 in item 3. Are present. Full stop. MSDP Learned Counsel appearing on behalf of MS Deka, Learned Counsel for the appellant, has sought an adjournment. Full stop. As the 2 appeals are connected, and the prayer is not objected to by the Learned Counsel for the other parties, please the appeals after 2 weeks on a date to weeks by the.
Oblige, man.
for hearing item number 4. Item number 5.
NDPS. NDPS. Sorry.
May please. Also, this is a appeal against the conviction on the NDPS Act.
How many appellants?
One only, Lords.
One.
One.
Pinak Songpur Basu.
So ganjas about 70 kgs.
Commercial.
It's commercial. So
Cannabis.
cannabis, so that has been seized from their vehicle. Initially, 3 persons were there, 1 person fled, and 2 persons have been caught there. And then contraband has been seized. Then the persons have been arrested and they have been convicted.
Let us see the FIR.
FIR is at page 1, it starts from page 1, but the relevant portion also will find at page 4. FIR? The FIR was filed on 21/5/2018 also. Humble submission is that as per reference mentioned above, and information is received in PS today that a car has been coming towards Borpeta from the direction of Guwahati via National Highway 31, and the car has been illegally carrying some amount of cannabis in it. On the basis of this information and under supervision of officer in charge of this PS, a search has been conducted by police in a silver-colored Hyundai Accent car, being registration number WB061392 on the road leading to Borpeta from the direction of Guwahati in front of Natkushi PP situated at National Highway 31, and found 12 packets of suspected cannabis of different weights wrapped in plastic. The person sitting in the driver's seat and in front seat, namely Shankar Yadav, son of so-and-so, Agartala, Tripura, and Pinak Chandra Basu, that is, he is the appellant, son of so-and-so, Agartala, Gandhigram, Tripura, are interrogated, and it is learned that the suspected cannabis are being carried in the car, said car, being registered number so-and-so, and though these 2 persons accompanied by owner name unknown, Tripura, are carrying this from Agartala to West Bengal. When the car owner, who was also traveling in the car, saw the police in patrolling duty conducting checks, he fled. The aforesaid seized articles are counted in presence of the senior-most officer and 7 packets. So in the FIR itself, Lordship, as far as the quantity is concerned, there are 2 versions. One says the 12 packets and one says the 17 packets. Cannabis are seized. As per the rules of NDPS Act, the cannabis and the vehicle are seized. The weight of the cannabis is 77.36 kg. Seized car along with the cannabis and the accused persons arrested at the place of occurrence and now kept in jail hazard. You are therefore prayed for the necessary legal action upon the investigation into the matter and oblige. So this is the FIR, Lordship. Then Lordship, page 8, Lordship will find the magistrate's order. After those materials were seized, is at page 8 here, Lordship. Dated 22/5/18, accused person Pinak Shankar Basu, aged about 19 years, and Sri Shankar Yadav, alias Shankar Rai, aged about 28 years, have been arrested in connection with an offense under section 20B2C of 29 NDPS Act. Seen the forwarding report, arrest memo, notice, inspection memo, medical report produced before me. The accused person stated that they do not suffer from any physical infirmity. The accused persons are arrested in connection with offense under section 20B Roman 2C/29 NDPS Act. The IO has submitted that the arrest of the accused persons were necessary for the purpose of investigation. The IO also stated that the accused persons were caught red-handed. The IO has also prayed for police custody on the ground that there is a need for custodial interrogation of the accused persons for apprehending the whole racket, and the accused persons are not cooperating in the process of investigation. Peruse the case diary. Considering all aspects, the prayer of the IO is allowed on the aforementioned grounds. Send the accused persons to 3 days police custody, that is till 25/5/18. The IO is directed not to torture the accused persons. He is further directed to ensure that the accused persons receives proper food, clothing, and medical attention. He is directed to ensure that the accused persons are examined by a medical practitioner every 24 hours. He is further directed to comply with the directions laid down by the Honorable Supreme Court in the case of D.K. Basu versus State of West Bengal. The accused persons were informed that they are entitled to engage a lawyer of their choice. They were further asked whether they are in need of any legal aid counsel, to which the accused persons have replied in negative and stated that they will engage their own counsel. Send a copy of this order to the Honorable Chief Judicial Magistrate, Nalbari, fixed 25/5/2018 for production before Special Judge Nalbari. Now, also later on, the IO of the case has submitted a prayer for seeing the seizure list and the seized articles. Prayer for the IO is allowed. Seeing the seizure list and the seized materials and the same are returned to the IO. The seized materials have been returned to the IO. The seizure list, Lordship, MR 18-18. So this 17 packets have been described here, and 18 is the seized vehicle. Serial number 18 is the seized vehicle. One silver color Hyundai Accent vehicle bearing registration number so and so. Silver colored, Lordship. Silver colored Hyundai Accent vehicle. Now, Lordship, later on again, page 10, Lordship. Also seen the prayer of the IO of the case to certify the correctness of the inventory, as well as permission to take photographs of the seized items of the inventory and certify photographs as true. Further, the IO has prayed for collecting samples of the seized articles in my presence, and also prayed to certify the correctness of the list of samples drawn. Prayer of the IO is allowed. Now, Lordship, I have certified the correctness of the inventory prepared as per section 52A of the NDPS Act, and have certified correctness of the enclosed inventory. The photographs enclosed are taken in my presence and certified as true. The list of samples are drawn in my presence and sealed. Out of 17 packets of suspected ganja, samples from packet number 1, 2, 3, 4 are drawn in my presence, which are accordingly marked as Exhibit 1, Exhibit 2, Exhibit 3, Exhibit 4, all in original and duplicates. The IO has further prayed for sending the samples of the seized articles marked as Exhibit 1, 2, 3, and 4 to FSL Guwahati for expert opinion. Prayer is allowed. There were 17 packets. Samples have been drawn only from 4 packets. There were separate 17 packets.
Is it in violation of 52B?
Lordship?
Is it in violation of 52A subsection 2?
That space 52A doesn't specifically say so, but I'll come to that, Lordship, later on.
No, I think there is no requirement of taking sample from all the packets.
Because, Lordship, what I think, Lordship, I feel if there are 17 different packets and samples have been drawn from only 4 packets, what about of the other 13 packets are not known?
No, maybe, but if all the packets are homogeneous packet comprising same articles.
The same articles, how it can be verified and how a conclusion can be drawn without
Okay,
testifying.
any authority?
That, Lordship, that I don't have it, Lordship.
No, because
I don't have- I'll come to that
this
later.
point is of vital significance.
Correct, correct.
Whether
Like, I tried to,
sample
yes,
of the homogeneous samples or homogeneous bundles are enough, or samples from each of the bundles are
yes, Lordship.
the mandatory requirement.
Correct, Lordship. Yesterday I was going through it, Lordship. I could not find a case law on this, Lordship. That's to be honest with you, Lordship, I could not find anything, but maybe there is something I'm not very sure about this.
So otherwise,
But I thought, Lordship, it will be a relevant aspect to point it out. to
52A
you.
is mandatory.
That is.
So I thought,
has to be
Lordship, it
complied.
will be.
That appears to be compliant. Now, what is the
Yes,
violation within 52A?
Yes,
You have to
52.
point out that.
Yes, the two things, Lordship. One thing is that like two defense arguments. One is 52A is not properly complied with because the witnesses, other eyewitnesses, they have stated something else about the sampling of the things, taking the photographs. And that is there. I'll take your Lordship to those things. And another thing is that, Lordship, while the trial was going on, that seized material was not produced before the court.
Not required if it is 52A.
No, the Supreme Court has recently, Lordship, in 2022, has stated that is fatal to the investigation process.
No.
That has to be brought to the notice.
Otherwise, we are of the view that
No, Lordship,
this 52A
no, Lordship. Lordship,
is complied with.
no, Lordship, that's the 52A only complying with the certificate doesn't help. That seized material has to be produced.
Because of subsection 4.
Yes, subsection 4 only, Lordship. Yeah.
Oh. So treat and inventory photographs of the narcotics and any makeup samples drawn on the swimsuit and certificate by ministry is primary evidence. Okay.
So,
Yes,
Lordship,
what-
this case was decided very recently, Lordship. This is 2022 SSC online section, Supreme Court 862. It was Mangilal versus State of Madhya Pradesh. These two cases, Lordship. I'll just take your Lordship to the relevant person. Very fast, Lordship. Lordship may kindly come to paragraph 3, Lordship. As far as the factual part, little bit, Lordship. Last 4 lines, Lordship. Both the courts place reliance upon the FSL report along with the police witnesses in rendering conviction. To be noted, the 2 witnesses bearing so-and-so so-and-so arrest memo have not been examined by the prosecution for the reasons based on to the right. That is different thing. Lordship, now page paragraph 5 here, Lordship. Paragraph 5 basically states down, Lordship, that 52A, the requirements of 52A, and 6 also says 52A. May I read out, Lordship? These are small paragraphs, Lordship. Subsection 2 of section 52A of NDPS Act mandates a competent officer to prepare an inventory of such narcotic drugs with adequate particulars. This has to be followed through an appropriate application to the magistrate concerned for the purpose of certifying the correctness of inventory, taking relevant photographs in his presence and certifying them as true, or taking draw of samples in his presence with due certification. Such an application can be filed for any one of the aforesaid 3 purposes. The objective behind this provision is to have an element of supervision by the magistrate over the disposal of seized contraband. Such inventories, photographs, and list of samples drawn by the certification by magistrates would constitute as primary evidence. Therefore, when there is non-compliance of section 52A of NDPS Act, where a certification of magistrates is lacking any inventory, photograph, or list of samples would not constitute primary evidence. 6, Lordship, obvious reason behind this provision is to inject fair play in the process of investigation. Section 52A of the NDPS Act is a mandatory rule of evidence which requires physical presence of magistrate followed by an order facilitating his approval either for certifying an inventory or for a photograph taken apart from a list of samples drawn. Now, Lordship, that provisions have been described. I will not take your Lordship to those. Paragraph 8, Lordship. Paragraph 8 discusses, Lordship. Before any proposed disposal and destruction mandate of Section 52A of NDPS Act requires to be duly complied with stating with an application to that effect. A court should be satisfied with such compliance while deciding the case. Lordship, what happens in this case is like this samples and like the contraband that was seized, that was not produced before the court. Only plea was taken that has been destructed. So there, in that context, this discussion was made, Lordship. Destroyed, not destructed, destroyed. A court should be satisfied with such compliance while deciding the case. The onus is entirely on the prosecution in a given case to satisfy the court when such an issue arises for consideration. Production of seized material is a factor to establish seizure followed by recovery. One has to remember that the provisions of the NDPS Act are both stringent and rigorous, and therefore the burden heavily lies on the prosecution. Non-production of physical evidence would lead to a negative inference within the meaning of Section 114G of the Indian Evidence Act, 1872. The procedure contemplated through the notification has an element of fair play, such as the deposit of the seal, numbering of the containers in seriatim wise, and keeping them in lots. Keeping them in lots preceded by compliance of the procedure for drawing samples. The stated principles of law are dealt with extensively in Noor Aga versus State of Punjab in 2008, 16 SSC 417. So, Lordship, that case has been discussed. Guidelines issued by this, we can skip, Lordship, paragraph 89 and 90. We can skip 91. Lordship, 92, Lordship, may come directly. 92. Omission on the part of the prosecution to produce evidence in this behalf must be linked with second important piece of physical evidence that the bulk quantity of heroin allegedly recovered indisputably has also not been produced in the court. The respondents contended that the same has been destroyed. However, on what authority it was done is not clear. Law requires that such an authority must flow from an order passed by the magistrate. Such an order whereupon reliance has been placed in Exhibit PJ on a bare perusal whereof it is apparent that at no point of time had any prayer has been made for destruction of the said goods or disposal thereof otherwise. What was necessary was a certificate envisaged under Section 1101B of the 1962 Act. An order was required to be passed under the aforementioned provision, providing for authentication, inventory, etc. Same does not contain within its mandate any direction as regards destruction. So plea was taken as destroyed since the materials were not produced before the court. 95, the High Court proceeded on the basis that non-production of physical evidence is not fatal to the prosecution case, but the fact remains that cumulative view with respect to the discrepancies in physical evidence creates an overreaching inference which dents the credibility of the prosecution. Even for the said purpose, the retracted confession on the part of the accused could not have been taken recourse to. Last but not the least, physical evidence relating to 3 samples taken from bulk amount of heroin was also not produced. Neither the material which has been seized nor the samples have been produced before the court. The same thing happened in this case also. Even if it is accepted for the sake of argument that the bulk quantity was destroyed, the samples were essential to be produced and proved as primary evidence for the purpose of establishing the fact of recovery of heroin as envisaged under 52A of the Act. Physical evidence of a case of this nature is nature being the property of the court should have been treated to be sacrosanct. Non-production thereof would warrant drawing of negative inference within the meaning of section 114G of the Evidence Act. While there are such a large number of discrepancies, if a cumulative effect thereto is taken into consideration on the basis whereof the permissive inference would be that serious doubts are created with respect to the prosecution's endeavor to prove the fact of possession of contraband by the appellant. Then, Lordship, this aspect of the matter has been considered in Jitendra versus State of MP also. Here also it states, Lordship, the trial, if in the trial it was necessary for the prosecution to establish by cogent evidence that alleged quantities of charas and ganja were seized from the possession of the accused, the best evidence would have been the seized material which ought to have been produced during the trial and marked as material objects. That hasn't been done in this case also. There is no explanation for this failure to produce them. Mere oral evidence as to their features and production of Panchnama does not discharge the heavy burden which lies on the prosecution, particularly where the offense is punishable with a stringent sentence under section and under NDPS Act. So later on, Lordship, that page under paragraph 11, at page 9, Lordship, they decide the issue. Lordship is a page.
Pair number?
Page 9(6), Lordship, that paragraph 6, bold, it was undermarked also.
Yes.
In our view, the view taken by the High Court is unsustainable. In the trial, it was necessary for the prosecution to establish by cogent evidence that the alleged quantities of charas and ganja were seized from the possession of the accused. The best evidence would have been the seized materials which ought to have been produced during the trial and marked as material objects. There is no explanation for this failure to produce them. Mere oral evidence as to their features and production of Panchnama does not discharge the heavy burden which lies on the prosecution, particularly where the offense is punishable with stringent sentences under as under the NDPS Act. In this case, we notice that the punch have turned hostile. So the Panchnama is nothing but a document written by the police officer concerned. Then, Lordship, they come to the conclusion at page 12, paragraph 14. Both the courts have mechanically placed reliance on the FSL report while taking the statement of PW11 as gospel truth. The views expressed by him can be at best be taken as opinion, at least on certain aspects. There are too many material irregularities which create a serious doubt on the very case of the prosecution. On a proper analysis, we have no hesitation in holding that the impugned judgments are liable to be set aside. The appellant is to be acquitted by rendering benefit of doubt. As a result, appeal is allowed.
Judgment আসলে এটা তো বলে স্যাম্পল কথা কইছে এটা যদি পলিটিক্স না করে এটা প্রাইমারি কোড দিয়া না হলো গতিকে বেনিফিট অফ ডাউট
22/5,
Lordship,
22/5/2018, right?
it start from page 8. And page 10, Lordship, that drawing samples were there. Page 10.
Order আছে।
Hmm?
কিছু order আছে।
It is after April 16 to 2019 on the date of judgment. Okay, judgment to get here.
এইটো দিয়া নাই।
To get here.
পিছত এইটো পিছত। Order আছে না 22 অ।
16/12. When the judgment was delivered
Lordship.
on 16/12/2019, there is another consequential order that the seized contraband items, ganja, be destroyed. So on that day only the order was passed. So the proposition the judgment has that without order of the magistrate, that has been destroyed. Here, some observation. I think that situation was not present.
But
In
that-
this case,
Correct.
just wait
Correct,
for a minute.
correct.
It was not destroyed. No permission was
Not taken.
taken and it was not destroyed.
They,
right.
they took the plea that it is destroyed, but the proper permission was not taken.
Where?
That case, Supreme Court case.
So the situation here is the contraband was present.
Yes.
It was not destroyed. And there was no permission also. So ultimately the court permitted it only on 16/12/2019 on the date of delivery of the judgment
For destruction.
for destruction.
That means that was there all the
It was
time.
in existence. So
Correct.
one proposition, one part of the case that the samples were destroyed during the trial, that is not the case factually. So now the proposition would be
Whether it's fatal
When-
or not produced,
when it was present,
but not produced.
but not produced. So
So-
this would be the situation.
Correct.
Right.
Correct. Correct.
So this particular observation in the context of that case.
That's right. But principle has been laid down that the seized material has to be produced. And it is the negative inference can be taken on the evidence like that had been stated. That was very clear, Lordship, very clearly stated that has to be produced. Language is that
No,
that has to be produced.
Mr.
But
Korita,
like when it was to be produced, then it has to be produced. If it is not, if it is destroyed, then it's a different thing. For destroyal, then for destruction, you'll have to take a proper order. Certificate has to be given. So the plea in that particular case of Supreme Court, Honorable Supreme Court, the plea was negated because there was no certificate. But in this case, Lordship, the contraband was there. It was destroyed later on, but the prosecution did not place it before the court, in spite of having the contraband. So the proposition of law is, in my understanding, is, Lordship, that if it is there, that has to be produced before the court. And that has not been produced before the court. So whether in that context, in that circumstances, it will be fatal or not.
Because this judgment is
That's right.
extensively, you come to paragraph 6,
Yes, Lord.
This judgment was one of the major part of this judgment is with regard to the notification.
Correct. Notification was there,
DSR 339.
Lordship.
And whole discussion is that certificate of destruction,
Correct, Lordship.
right?
Correct. Lordship. Correct.
Here, this kind of disposal was not done.
Correct, Lordship.
It was in existence.
Correct, Lordship. Correct. That is.
Slight variation in facts
That's
makes a
correct.
whole lot of difference in the decision-making process.
Correct, Lordship.
That is also a law,
No.
right? Here, the whole discussion is regarding non-production of and destruction of the contraband without permission of the magistrate.
And because the plea was taken by the prosecution. Because the plea was taken by the
And
prosecution,
this
that
GSR was taken note of. Mode of disposal of drugs was taken note of. And a certificate of destruction contained therein is taken note of. Then come to paragraph 7.
Yes, Lordship. This discussion was necessitated because, correct,
Because-
Lordship. Correct.
This judgment is rendered with the context in the context of the GSR notification, the facts and circumstances obtained in a case.
I agree fully. Fully.
So for discussion in paragraph 6 and 7
Lordship.
are with regard to that.
Correct, Lordship, correct. There's no dispute about this, Lordship. Because they have taken a plea that
Now that situation was not here.
was not here.
Now,
That this discussion was important in
Ah.
the Supreme Court case, in my humble submission, Your Lordship, because they have taken a plea that we could not produce it because it was destroyed. But here not the case is
Here
not
is
happened.
not.
Here not because
Now-
they have not done it themselves.
how this then subsection 4 of section 52A is to be interpreted?
Yes, that's Lordship has to.
That
Because
so
here-
otherwise this is substantive provision. This is law.
I also gone through because
Right.
this.
This is judgment.
Yes.
There is a difference between law and judgment.
But they have, yes, but they have specifically discussed about this. Lordship.
It will go to the section model. Yeah, otherwise too. Not listening, every court trying and open the inventory. Photograph of the so-and-so. So-and-so, control substance, so-and-so, and primary substance, primary evidence. Subsection 4 of section 52A. That is the law. Which cannot be overreached by.
That I have gone through, Lordship, that I have gone through that
So-
it is a primary liberal law. But it says that 52A compliance is also that seized material has to be produced before the court.
Where is that?
That is specifically stated, Lordship,
Which one?
that I have read, Lordship, space 6, Lordship, paragraph 92. This was discussed in case of Nuraga.
Let us see once again. Because so many judgments this side and that side.
Because, Lordship, it is a very specifically, they have come to this conclusion, Lordship.
Before any.
92, Lordship.
No, you prepare, you starts with paragraph 8, right?
Yes, Lordship, paragraph 8.
You read the first line.
Yes, before any proposed disposal, destruction mandate of section 52A of the NDPS Act requires to be duly complied with starting with an application to the
That
effect.
situation is not here.
Yes, that is not there. That is not there. There, I agree, Lordship, that is not there. That is not there. That's the difference between these two cases. But in both the cases, the contraband was not produced before the court. That was the issue, Lordship. And in that circumstance,
No,
what is the
that
law?
that situation, that section 114 is that they have destructed without permission. Otherwise, which requires permission. So that is an adverse and inference that can be drawn. Presumptive. It is presumption. To effect which
So
that they have destroyed, they have admitted, they have destroyed. So that fact is established. Presumption can be drawn from an established fact.
that, yes,
Right.
yes.
This 114, this is not that, in that context, it will not be drawn. That the contraband has been destroyed. It is an established fact. So 114A presumption is permitted to be drawn. But here is not the fact. It is not an established fact.
It was not,
The contraband is in existence.
the Lordship, it was not the fact in the case of Noor Agha also, which was discussed.
Let us
In
see.
this case. Yes, Lordship. It was, that fact was there, not there. It was the
Court
principle
should
was
be
laid down.
satisfied with such compliance
May I
with
read down,
deciding
Lord?
fact. Yes.
Yes.
I am
A
not-
court should be satisfied with such compliance while deciding the case. The onus is entirely on the prosecution in a given case to satisfy the court when such an
Such an
issue
issue
arises for
for
consideration.
consideration.
Production of seized material. Production of seized material is a factor that establish seizure followed by recovery.
This part is 52A.
Production of seized material is
Production of seized material
is a factor
to establish seizure
of
followed by recovery.
recovery.
This is 52A,
Correct.
subsection 2.
Correct. One has to remember that the provisions of NDPS Act are both stringent and rigorous, and therefore the burden heavily lies on the prosecution. Non-production of a physical evidence would lead to a negative inference within the meaning of section 114G of the Evidence Act 1872. So it doesn't say whether it is destructed, whether it was still there. There was no qualification has been put on this line, Lordship.
No, you have to read it with the
Yes,
following.
then the procedure contemplated through the notification has an element of fair play, such as the deposit of the seal, numbering of containers in seriatim wise, and keeping them in lots preceded by a compliance of the procedure for drawing samples. The aforestated principles of law are dealt in extenso in Noor Agha versus State of Punjab. Now, 89 year Lordship, guidelines issued should not only be substantially complied with.
What is the guidelines issued?
In that particular case, Noor Agha, there may be some guidelines were there.
What are the
But
guidelines?
but the principles also will come to the later paragraphs. To paragraph 90,
Yeah. Paragraph 96.
paragraph
of
92,
Noor
Lordship.
Agha.
92, then 96, your Lordship. Then 100.
No, whether it is laid down the law, last but not the least, physical evidence relating to 3 samples taken from the bulk amount of heroin was also not produced.
The
That is in the
sample-
context of the case.
Correct. Sample was also not.
Even if it is accepted for the sake of argument that the bulk quantity was destroyed.
Yes.
Here it is not the case.
Not.
The samples were essential to be produced and proved as primary evidence for the purpose of establishing the fact of recovery of heroin as
Envisaged.
envisaged under section 52A of the Act. Now, in what context?
So it says that
Whether it appears this observation prima facie, not in total conformity with subsection 4 of section 52.
that your lordship will decide.
No. I'm saying prima facie. So it is, ball is put in your court.
So it says, lordship, that lordship, this is very clear in my humble submission, lordship. This is the law they have laid down, lordship. I mean, whether it's destroyed or not, prima facie, you'll have to produce the seized material. If the seized not the seized material, at least the samples before the court.
That is what we are trying, whether samples are really required to be produced before the court. When a procedure prescribed in 52A subsection 2 is evidently followed. And in the context of subsection 4. Because it says, law says it is primary evidence. You know. Any other point?
Other points, there are some contradictions regarding whether the samples were taken before the magistrate or it was taken prior to that. Because the statement of witnesses vary, lords. The eyewitnesses. And whether the photographs were taken before the magistrate.
Better like exhibit 1, better like exhibit. Heard of photographs of seized ganja and vehicle that were seized by exhibit 1. तो 52 तो comply को रखा था ये 52 तो their evidence
Testimony of
I-
PW4. Testimony of PW4?
Yes, particularly for lordship,
Huh.
lordship will see. I'll just read out, lordship. I just wanted to show.
Not record one part. Now, we are just pasting your case. PW4,
Yes, lords. PW4 is the OC, he was the investigating officer.
oh, you very.
say
Photographs of bulk samples, bulk contraband. Those were exhibited as material exhibits.
Yes. Yes, that is there in the Caesar list, lordship.
Not serial is.
No,
as,
No, that's lordship will find that in.
PW4
Yes.
to him.
Yes, yes.
Those were exhibited.
Yeah,
And 313 questions were put.
yes, lordship. The lordship may kindly see the, it may be important, lordship, that page 49, lordship, prosecution exhibits. Page 49.
Or wrongly put.
Yes.
Wrongly listed. Come to testimony of PW, come to page 29 first. Question number 8,
20.
question number 9,
29, Lordship,
Page 29, question number 8, question number 9.
yes.
And come to testimony of page 25 also. Question number 8.
That Lordship, exhibit, that material exhibit
Material
number.
exhibit. Now come to page 20. Second, third, fourth, fifth paragraph.
20,
Page
page 20,
20,
Lordship,
fifth paragraph.
page 25th paragraph.
So material exhibit 1 to 8.
8 are
Those were not
photographs.
listed in the page
49.
in the judgment.
In the, it's
But
not.
it is there.
It is material exhibit they have done, but that was not produced before the, oh, it is there, it is there. Okay.
We have seen
There,
it.
there.
নামটো মাঙ্গিলাল মাঙ্গিলাল Is there any evidence that they have destroyed?
No, no,
In a
no, no
testimony?
evidence. In the paper book, nothing.
No, in a testimony.
No, Lordship, it is not there. No, that issue hasn't come cropped up in the whole proceeding. Only one question was put up, Lordship. I'll just that reply was in the cross examination of the PW4, page 21, yeah, Lordship. So what is the middle, Lordship? Upper middle side, page 21. Prosecution did not show me the seized contraband items today in the court.
I think something is required on subsection 4 of section 52A.
If your lordship allows me some time, then lordship, I may be able to lordship
All
get
these,
something.
because Mohanlal and all these, I have found, just like on a cursory glance, that 52A either did not happen or this disposal was made. Disposal was made, right from Mangilal also, all these disposal was made, right, like
It was
that.
extracted.
Here is subsection 4 of section 52A is staring at our face. And all these photographs, inventory,
That
these will be treated, photographs of conveyance also will be treated as, and any list of samples drawn under subsection 2 and certified by the magistrate as primary evidence in respect of such offense. So there is no better evidence than primary evidence. So if it is equated to primary evidence, and
Whether that
those
can
are
be-
the exhibited, material exhibit 1 to 8. You might not have seen that
that I have seen.
because the in the list
Oh, yeah, that is there.
behind the judgment, it was not there.
Mm.
But questions were put to the accused and PW4 exhibited those material exhibits. And
Because-
those are part of a record. We have seen also in a seal cover.
Correct, correct.
So it is in that context whether this is not sufficient. Here it is not the case that it has been destroyed. Presumption under section 144G is available to be drawn. Presumption is to be drawn from an established fact. Here it is not established. There is an order of the special code that seized contraband be destroyed. So the presumption would be with presumption that it was in existence,
It was in existence but not produced.
not produced. But in the face of subsection 4, that
That's-
is what
That I am also, lordship, I was also a little bit,
that
that
is
let,
what.
two things, lordship, I mean, one thing
If-
is,
Suppose he used contraband of in a ship.
but the samples, lordship.
Samples is also not required as per subsection.
Samples were not produced. That has been also specifically stated in this case, Nudaga. I will read out lordship, if lordship allows me
Find
some
out.
time.
Ah.
Lordship, two things, lordship. One thing is that as far as if there are 17 packets, they should have collected samples from each packet or not. And secondly, lordship, this 52A4.
Whether representative samples are allowed to be drawn or samples are from each of the.
Because those samples were not mixed together to make it a homogeneous pack. If it would have been a homogeneous pack, all the packets are mixed together, then sample was taken from that, that would have been a different thing.
That is not a requirement.
No, that's what I.
Law is well
Yes.
settled.
No,
It is not
lordship,
required to
no,
be-
lordship, I am just thinking.
You find out.
I could not find anything. I'll try to
Representative
find out,
samples-
lordship. I'll try to find out.
Representative samples are the norms or it will vitiate the proceeding.
No, I was just like thinking about myself only. I was thinking myself that if there are 20 containers, the 20 containers, 5 containers, you have taken the sample and 15 you haven't taken. Those may be different quantities of whole.
What is the intention of the parliament? Find out.
Yes, I think that will be, that may be a relevant. Lordship.
Because 52A subsection B,
Yes, Lord. 52A subsection
subsection B C,
C,
allowing to draw representative samples of such drugs.
substances.
Representative samples.
Correct.
So what is the, it can be, can have two meanings. That the 17 packets are available. Representative samples are to be drawn from each of the 17 packets or at least a few. Find out.
Or they would have taken from one only then. It would have sufficed. I'll find out, Lord.
Ifs and buts will not do.
Lordship.
Ifs and buts will not do.
Correct, correct. No,
I
I'll
think it
I'll
is
find
law
it.
is there.
I'll find it. Lordship, yesterday I was going through, I was trying to find out, but I could not get
And
any
two
case.
things,
law.
and in the context of subsection 4 of section 52A.
Whether that has been discussed or not in any other cases.
Otherwise, in NDPS case, laws are, authorities are there.
Lordship.
Seizure witness do not turn up in many of the cases. Now, Supreme Court has held that will not
VCA, the-
initiate the trial. Police witnesses are sufficient unless some material irregularity.
correct.
That is a law. So find out this. I've not gone through recent decisions, so I don't know.
Baldev Singh or something, constitutional bench.
Baldev Singh, 1998 onwards. Find out these two aspects.
What
Because-
is the other point?
Other point, Lordship, I mean, the two witnesses, eyewitnesses, two eyewitnesses were there. There were some contradictions regarding whether a sample was taken before the magistrate or not, and the photographs of the sample were taken before the magistrate or not. There was some, it's not very clear from the statements also. There was some doubt.
There is order of the magistrate.
Order of the magistrate is
that-
there, Lordship.
in the-
Order of the magistrate is there.
If that is reflected,
Order of the
a
magistrate is
second
there.
view,
I just wanted to point out because there was some discrepancies. It looks like there are some discrepancies, but order of the magistrate is there. That is there. So that is because these two witnesses said one is a photographer. He went to the spot where the materials were seized, and he took the photograph there, and samples were taken there only. A statement like that. So it's not very clear.
samples from so and so, packet number so and so are drawn in my presence.
Yes, presence where
Ah.
he went to the place of occurrence.
Who?
That witness, Lordship. That witness has gone to the place of occurrence. He was called to take photographs in the place of occurrence of the seizure. Not before the magistrate, Your Lordship. There was no statement that he was present before the magistrate.
Oh, when then you are trying to test the validity of this order.
No, I am not,
If
Lordship.
you
I,
say,
Lordship,
then,
to be
seizure-
honest with you, Lordship, I haven't done much of the NDPS cases. This is one of the few, I mean, one
Yes,
of the few
yes.
cases
No, no,
I have
no.
got. So, Lordship, I just want to
Uh,
point it out.
Try to find out that this representative sample,
Lordship,
only 4 out of 17 is
sufficient,
not enough.
correct.
That samples are to be drawn from each of the 17 packets. And secondly,
Therefore,
the subsection 4, which law is settled,
Lordship.
then whether by saying that samples are to be produced, the
Before the
court
court,
can go beyond.
that I'll look into.
beyond-
I'll try to assist you, Lordship.
beyond court territory. Only law cannot be laid down. Law, but that is in the context Nuraga, find out Nuraga. Find out Nuraga and Mohanlal. What is the,
In a different factuals, I'll find out.
we
I-
cannot pick up.
Correct. No, I'll definitely.
Here it is established, Mongilal,
Hmm.
things are destroyed.
Correct.
Right.
I'll find out. That Nuraga
We'll
also,
put
Lordship,
it in the next week.
Lordship,
We'll put it in the next week.
next week, Lordship. Can it be on, Lordship, on 25th or 25th? Lordship? 25th,
We'll
Lordship.
put it in the next week only.
Next week, Lordship, full of some part matters and all. Lordship.
Okay, we'll accommodate, no problem.
25th,
No
Lordship.
issue.
25th, Lordship. Grant me some time. I'll have to do some research work also, Lordship.
Okay.
25th, Lordship.
Mr. Ekolita, learned makers for the industry for the appel. And Miss Abraham. Yes, what do you say? No,
Go through Lordship about the 17.
you can
packets.
say that
No, no,
these
no,
are not required
No, no.
from the authorities, we can decide.
No, I'll have to see, Lordship, that whether the samples may be taken from 17 packets or 4 is suffice.
And secondly,
Secondly, that it is
Mongilal,
Mungilal, and also it is taken before the magistrate, Lordship. I have seen from that, Lordship. I'll rest, I
whether
will
52A subsection 4.
note down, Lordship.
Okay. A Bagam, learned additional public prosecutor. For the respondent state post on the prayer of the learned counsel for the parties leaves the appeal. The case again on. Lordship.
Benefit.
Benefit.
May I please your lordship. Lordship, 302 offense between the family lordship.
Can you take the mic near your? Yes.
302 lordship.
Hmm.
Accused is the brother-in-law of the deceased. Accused younger sister is married by the deceased.
Accused is the brother-in-law.
Yes, lordship.
Okay. Husband's brother.
No, wife's elder brother. Wife's husband was killed by the brother of the wife,
Her brother.
her brother.
Okay.
And the Jahar is by the wife of the deceased and sister of the accused, lordship. It's a small Jahar, page 4 of the paper book. Humble submission is that around 6:30 p.m. today, that is on 10/1/2014, the said respondent Nasim Akhtar killed my husband Mohammed Mobin, aged 33 years, inside my house by stabbing with a dagger. It is therefore prayed to take necessary legal action and oblige. So here, according to her, as per the evidence, as per the Ejahar lordship, the accused killed her husband by stabbing with a dagger inside her house. That much is the Ejahar lordship. It is the evening time. It's almost 6:30 p.m. on in the month of January 2014.
Hmm.
All along, he is in jail, lordship, from the date of arrest, lordship. I have gone through the order sheet. So the date of incident is 10/1/24. On the very day, same day he was arrested. So it's 10/1/14. So it's almost more than 10 years. He's
Cosley says 8 years, 11 months.
lordship, possibly, lordship, they had calculated it previously because date of I have gone through the order sheet. He was
Okay.
produced all the time from jail. So, lordship, this PW1, as per the judgment also, lordship, PW1 and PW2. PW2 is the father-in-law of the deceased. Actually, they used to stay in the house of the wife of the deceased, lordship. In fact, he is a driver in Saudi Arabia. He had returned from Saudi Arabia just a few days back.
Who,
Of the
husband or the
yes,
accused?
deceased, lordship. So PW1 is the wife. I am the complainant of this case. Exhibit 1 is the Ejahar lodged by me and Exhibit 1 is my signature diary. Accused is my own elder brother. Around 5:30 p.m. on 10/1/2014, the incident took place. The incident took place on the road behind our house. So in the Ejahar, it is stated that inside the house, lodging. In the morning of the day of incident, my aforesaid accused brother assaulted my deceased husband. Then I got the Ejahar written regarding the incident of assault, but I did not lodge it in the police station. Later, my accused elder brother came to the room in the evening. My husband and I live in a room in the front side of my parents' house. We got married as a result of love affair. When I saw my accused brother, I asked him why he assaulted my husband in the morning. Then the accused says me to assault. When I raised a hue and cry after falling down, the accused brother fled away and he met my husband on the way, and after assaulting my husband with a dagger, he was standing there. I too ran after my husband. Then I saw the said brother and my husband standing face to face. On seeing me, brother fled away. Then I held my husband when he was about to fall on the ground, and I saw that blood was oozing from my husband's chest. Then I screamed, thinking that my husband was dead. Hearing my scream, my father Hassan Sheikh came and held my husband. My father also raised alarm. Leaving my husband with father, I went to the police station. At that time, my clothes were stained with blood from my husband's injury. My husband was taken to the hospital by bringing a 108 ambulance from the police station. Later, my husband died. Cross. The accused is our elder brother. He lives separately. I stay with my father. My father's land is yet to be divided. My accused brother did not accept our marriage. My husband was a driver in Saudi Arabia. I got married on 3/9/2011. After marriage, he went to his workplace only once. Later, after coming from there, he did not return. The said brother and we live separately in our father's house. Around 8 a.m., the accused assaulted my husband. My husband was about 31-year-old. I saw the dagger at the time of taking it out, which was stained with blood. So here, as per the cross lordship, I saw the dagger at the time of taking it out, which was stained with blood. So she had not seen stabbing it. As per her cross, she had seen it when he was removing it, lordship, when taking it out. So that is her evidence. And now as PW2, who is the father, he is the next person who came after hearing the cry of his daughter. PW2, accused Nasim Akhtar is my son and complainant Ambia is my daughter, and this is Mobin Sheikh is my son-in-law. Around 6:30 p.m. on 10/1/2014, the incident took place. At that time, I was at home. Thereafter, hearing hue and cry in the direction of the road beside the house, I came out and saw that the accused and my son-in-law were entering the backside of the house through a narrow path. Then I ran towards the backside. There was an iron pipe in the hand of my son-in-law. The accused was on the backside. When I went to resist my son-in-law, he pushed me down. My daughter Ambia was with me at that time. And holding my son-in-law, she said that father, a murder is committed. Holding my son-in-law who became unconscious, I sat down on the ground and sent my daughter to inform at the police station. Then the police reached the place of occurrence with my daughter. They took injured son-in-law to the hospital. I saw only my accused son and son-in-law entering the narrow path, and I did not see anyone else. The murder was committed after breaking down the fencing there. It was dark at night. I did not see committing the murder. My daughter came running and screamed, "Father, a murder is committed." At the time of incident, only my son-in-law, my daughter, and I were present at home. So as per him, lordship, he saw them. Then his daughter was also with him, and he had not seen the murder or the commission of the offense. He had only seen these two persons, and then her daughter had screamed that a murder is committed, and it was dark according to this witness logic. PW3 is another brother of the informant lordship. He is only hearsay evidence. The complainant is my younger sister. Accused is my elder brother, and the deceased Mobin is my brother-in-law. In the evening on 10/1/14, the incident took place. I was not at home at the time of occurrence. I went to work. In the morning on the day of occurrence, a quarrel took place between accused elder brother and deceased son-in-law. Before I left for home for work, I told them not to fight. Later, coming back home from work, I saw that many people had gathered in the house and there was crying going on in the house. When I asked my younger sister Ambia why she was crying, she said that accused elder brother had killed brother-in-law Mobin. I did not see the occurrence. PW4 is Deepak Raman. His evidence is regarding this seizure of a knife. Although lordship, as per Azahar and the evidence, it was a dagger, but the seizure is of a knife, lordship.
So what is the difference between dagger and knife?
Lordship, possibly dagger is a larger weapon than.
Bigger in size.
Yes, bigger in size. Ambia Khatun lives near my house. I know the accused also, he is the elder brother of Ambia. The incident took place a year ago. I heard that the accused had killed his brother-in-law, Ambia's husband, with a knife. Hearing about the incident, I went to the place of occurrence and saw the injury on his chest caused by the knife. When the police arrived, the accused himself saw the knife which was used in the incident. The police seized the knife in presence of me and obtained my signature in the seizure list. Exhibit 2 is the seizure list and Exhibit 2(1) is my signature as a witness. Cross. The accused is the son of my maternal aunt. The incident took place on a narrow path near the accused's house. At the time of incident, I was at a distance of half furlong from the place of occurrence. Hearing a hue and cry, I arrived at the place of occurrence. Around 7 p.m., the incident took place. I saw Ambia and his father at the place of occurrence. I do not know the name of the deceased. PW5 is the doctor. On 10 January 2014, I was working at North Lakhimpur Civil Hospital as medical and health officer, and on that day, I performed post-mortem examination over the dead body of Mobin Sheikh, aged about 30 years so-and-so. On examination, I found male dead body of average build, rigor mortis present in all the 4 limbs, eyes closed, face pale. A small lacerated injury over the left side of the chest, size 2 inches over the nipple. Return at level of 3rd rib lift. Left lung healthy, covered with full of blood, about 3 liters. Right side of the heart is full of dark fluid blood. When left side is injury, fracture 3rd rib left side. All injuries described above are antemortem in nature. In my opinion, the cause of death was due to stab injury to major pulmonary vessels, which caused massive intrapleural hemorrhage. Exhibit 3 is the postmortem examination report, and 3(1) is my signature. Cross. On repeated calls, the learned counsel for the accused failed to appear before so-and-so, and in the down of the page, lordship, on 10/4/15, Dr. Cross is that I found stab left side injury just above the nipple of the deceased. So that is the cross subsequently taken on 10/4/15, lordship. PW6 is subsequently he is the IO. He is not the IO, but subsequently he had gone through the evidence examination of the lordship. On 12/7/14, I was working as attached officer at Bipuria police station, and I am still working there. On that day, the OC of the police station took the case diary from investigating officer of this case, SI Monjit Terang, and entrusted me the charge to complete the investigation. After taking the charge, I went through the case diary and found that the former investigating officer had almost completed the investigation, and only the knife used in the incident was not produced in the court, and then I got the seizure list seen after producing the seized knife before the court. As sufficient evidence was found against the accused for committing an offense punishable under Section 302 IPC, I had submitted the charge sheet. I did not recover the knife. I did not collect the fingerprint of the knife. PW7 is the IO. On 10/1/14, I was working as attached officer at Bipuria police station. On that day, when the OC of the police station entrusted me with the charge of the investigation, I assumed the charge of the investigation. When I found the complaint in the police station itself, I interrogated her, and after recording her statement, I went to the place of occurrence in her house. Since it was night when I reached the place of occurrence on the day of the incident, I recorded the statement of the neighbor. I came to know the injured Mobin Sheikh was taken to Bipuria PHC for treatment by ambulance shortly before I reached there. I came to know at the place of occurrence itself that the injured had died on the way. When I was there, I came to know that accused Nasim Akhtar had fled away after committing the incident. Then I, along with my staff, went in search of the accused, and later finding the accused near the Hanuman temple, which is located near the place of occurrence, I apprehended him. Thereafter, the accused was taken to the police station. Thereafter, on the night of the day of incident, I again proceeded toward Bipuria police station, Bipuria PHC, to prepare the inquest on the dead body. The inquest report was prepared in presence of circle officer. His name is so-and-so. I can recognize it. Thereafter, the dead body was sent to Lakhimpur Civil Hospital for holding post-mortem examination in that night itself. I again went to the police station and interrogated accused Nasim Akhtar. Next morning, again, I went to the place of occurrence. Reaching there, I draw the sketch map of the place of occurrence. Exhibit 6 is the sketch map. Thereafter, when Arfan Ali Ahmed, OC of the police station, called me to the police station over phone, I came back to the police station and again I reached the place of occurrence, taking the accused along with me and recovered the knife used in the incident as shown by the accused. Then I drew the sketch map of the place shown where the knife was recovered. So and so. At the time, I seized the knife after preparing a seizure list. Thereafter, I sent the accused to the court. Thereafter, I collected a postmortem report. After doing all this, since I got transfer, I handed over the case diary to the OC of the police station. Cross. The house of the accused is situated within 5 to 10 meters from the place of occurrence. The complainant is the own younger sister of the accused. When I reached the place of occurrence, a lot of people had gathered there. While examining the witnesses, I came to know that the injured had died on the way. The complainant and her father were eyewitnesses. It was said that the accused had killed the injured. The knife as shown by the accused was recovered in a culvert located between the Magic Vehicle Stand and Hanuman Temple in Bipuria town. The knife was recovered half-kilometer away from the place of occurrence. Around 10 p.m. on the day of occurrence itself, the accused was arrested. I do not know how long the narrow path was. So these are the evidences, Lordship. Although it is the IO also stated that the PW 1 and 2 both are eyewitnesses, but as from the evidence of her father that he actually had not seen the commission of the offense, neither PW 1 had also seen the
Fraction of a
Stabbing.
moment,
stabbing
fraction of a
part.
moment,
Yes.
there he is, he
But it-
was present in the vicinity,
Vicinity.
close vicinity, inside his own campus.
Inside there is a narrow path and both of them came running from the
Hmm.
place of occurrence. Place of occurrence is 5 to 10 meters from the home, Lordship. And it was actually 6:30. It's in the month of January. It's possibly not that much light was there outside, Lordship, because light, whether there was any street light, etc., that was not.
Husband and own brother, presence of no other, husband and own brother.
Yes.
And something was there.
Some incident.
The relationship is not that good. But the other brother said there was a morning quarrel also. He has corroborated the informant in that there was a quarrel in the morning between you two,
Yes.
the deceased and the accused.
Accused.
And he said to them, don't fight. But that fight repeated, apparently. So what is your,
Lordship,
what is the defense? Defense has not taken anything.
no, Lordship.
You have not objected to the seizure of the knife at another place. In
Yes.
fact, it was shown by him according to the IO and as per the seizure list. And this PW Deepak
Deepak
Rama,
Rahman.
PW4, he also says that he was not challenged.
Lordship, 330 statement, Lordship, no question was asked so far the evidence of PW7 regarding the leading to that seizure, Lordship. If Lordship kindly see page number 23, it starts 330 statement.
Mhm.
Although there is a question was asked so far, PW4 is
He
concerned,
said,
Lordship, but
again, I reached the PO taking the accused along with me. Recovered the knife used in the incident as shown by the accused. Then I draw the sketch map of the place shown where the knife was recovered. That is Exhibit 7.
7. So
At that time, I seized the knife after preparing a seizure list. PW4 was the witness.
3
He was
witnesses.
not, three, one
But
is enough.
only, yes, yes. No independent witness was also there, Lordship.
Then, cross, you have elicited that no knife as shown by accused was recovered in a culvert located between so and so. You have not challenged the
But
seizure also.
313, that opportunity must have given to the accused regarding what was the evidence of the PW7, the IO regarding, at least that is the one of the most incriminating eyewitness. There are some discrepancies are there, Lordship. PW7 IO
Material.
checklist stabbing is not seen. And yes, she is also an interested witness. So far, because she is the, all the time we cannot ignore the interested witness, but she is an interested witness, in fact, in both sides.
Related witness, yes, to both sides. But notwithstanding the
Because-
testimony of the informant, what about the father of the accused and the brother of the accused? Whether they had some enmity to implicate the accused wrongly, there is nothing.
Brother of the accused had not implicated.
No,
the
he
morning-
corroborated. He
yes, morning
corroborated
incident.
the informant that there was a quarrel between the accused and the deceased in the morning. And he told both of them that don't fight, don't quarrel. Then he left for his place. At least that part, informant's testimony that there was a quarrel in the morning also.
Lordship.
One thing.
One more thing is that, Lordship, although PW1 had stated in her evidence that when I saw my accused brother, I asked him why he assaulted my husband in the morning. Then the accused says me to assault. How he says, he just says, and he is saying with a dagger or any other, that is also not there. So his her only evidence, then the accused says me to assault.
It is. Yes, anything more?
Yes, Lordship. That as per her evidence, Lordship, accused says me to assault. When I raise a hue and cry after falling down, accused brother fled away and he met my husband on the way, and after assaulting my husband with a dagger, he was standing there. So she had not seen those. She falling down, and as per PW2, he
So,
saw, then she
What can
subsequently
be
came.
drawn from that? Only two persons.
Because incident took place outside, Lordship. The narrow path, both of them are coming, and he is just pulling the dagger. So it cannot be said that he had stabbed, and then why he will pull when he had to fled away, again pulling and taking it with him.
No, other side also that the accused, the disease will not put the dagger in his chest. There is nobody present except you and the disease. That is what the father says and the wife says.
Father said that he is having an iron rod and coming, and
See your strength of cross-examination.
that is true. And it was
PW1. PW1.
Lordship. Yes, Lordship, that is
have
true,
not
Lordship.
confronted her with anything substantial,
That is
not
true.
even a suggestion. Not a single suggestion also to find out any defense plea.
And as per PW2,
Two also,
yes, one thing.
only one thing positive is that he put in his mouth, PW2, that there was an iron pipe in the hand of my son-in-law.
And the accused was in the back side and the injury in the front side, in the chest. And as per PW2, the accused was on the back side.
Whether truthful or not truthful, that is the issue. Otherwise, core of the prosecution case is that accused stabbed.
Stabbing, but that was not
Stabbing is not there, but at least medical evidence is there.
in a
And
narrow path,
corroboration is there.
Lordship.
At least she saw.
Has not been put into question. However, it is stated that it is knife, Lordship. In the Caesar list, the knife length is 9 inch, Lordship. It's quite a big Lordship, large Lordship. Moreover, Lordship, if I look into the medical report, Lordship, here fracture on third rib left side is also there, Lordship.
Mm.
And quarrel part is also not question, Lordship. The quarrel is definitely there, Lordship. It is not that small, Lordship. The fracture is also there. In page 44, Lordship.
Mm.
That is what I also want to point out. The fracture and stabbing
Lordship,
will not cause fracture, Lordship.
No, you did not put any question to the doctor.
Yes, because he had not fall. He was
No,
supposed
no,
to fall.
the injury is chest, on the part of his chest. Then
this clear?
Yes, Lordship. Moreover,
To a small lacerated injury over
Doctor.
left side. 43 is the
We
examination.
have seen the postmortem.
Yes,
See the postmortem.
42.
The
Relevant.
cause of death was due to stab injury
Lord-
to major pulmonary vessels which caused massive intrapleural hemorrhage. And if you take 15-16 hours from 2 p.m. on 10/1/2014, it appears correct.
moreover, PW1 also stated, Lordship, I saw that the blood was oozing from my husband's chest, Lordship.
Chest. And what are the other injuries?
Only one injury.
Only
Yes.
was small lacerated injury over left side of the chest, 2 inches above the nipple. A small lacerated injury over left side of the chest, 2 inches above the nipple. Third rib fractured.
Lordship.
Pleura ruptured at the level of third rib. So it is okay.
In page 44/7, heart also, Lordship. Right side of the heart is full of dark fluid, blood,
And the left lung
Lordship.
is full of blood, about 3 liters. It is from the, perhaps from the injury. And then heart, right side of the heart is full of dark fluid blood, while left side is empty. Third rib is connected with the stab injury. Third rib fracture is connected with the stab injury. And what is the size of the knife?
9 Lordship.
9 inch.
Lordship.
Seizure list
Seizure list 40,
40.
40.
One knife length approximate 9. And PW4, he specifically deposed about the seizure of knife.
Lordship, there one point I want to
Yes.
point out, Lordship, that as per PW7, seizure was on the next date, means 9 a.m. as per the seizure list also. And he had also stated that, Lordship, thereafter when Arfan Ali Ahmed called me to the police station over phone, I came back to the police station and again I reached the place of occurrence, taking the accused along with me and recovered the knife used in the incident as shown by the accused. So from the above, it is clear that it is in the very next date. Incident is 6:37 or 6. And if I read the evidence of PW4,
The
he said that I
And you
went
did not ask anything.
Lordship, his evidence that when the police arrived many times. First they arrested, secondly they came.
Police
When
arrived,
actually-
actually to show the knife, which was used. Now, he is not related to anybody. This man,
He is related to both.
he is near the house.
Never.
I know the accused,
I went to the place of occurrence and
he is
saw that.
not related to anybody.
No, he is related to both. He is
Oh.
son. Accused is the son of my maternal aunt. So she is the daughter of his maternal aunt.
No enmity.
Right. But
So,
I
he is
went to
very
the
much.
place. He may is an interested witness also.
Cannot
Lordship,
be-
cannot
Where
say.
is that evidence? Interested, just because related, you cannot put
Because
it in
there
the
are-
pedestal of interested. Interested has to be that he must be interested in putting the accused
And
under implication because of something more.
3 Caesar witnesses, only one was examined.
Is the requirement?
And
Requirement in law?
no logic, but 313, no question was asked. Yes, logic.
Will be to PW4.
PW4 is there, but 7 is the IO lordship. But no opportunity was given.
No, no, madam, it is circumstance wise, not witness wise. That circumstance was put to the accused. The victim of seizure is put to the accused.
It is the incriminating circumstances which are to be put to the accused. Not that what several PWs might say that witness where knife was recovered. It is the circumstance, that incriminating circumstance that knife was recovered. That is to be put. Not that PW 1, 2, 5, 10, 12 has said. That these witnesses have said that a knife was recovered in their presence from so and so. That is the incriminating circumstance, not the number of witnesses. That is put. So it is culpable homicide, then murder, and culpable homicide not amounting to murder. If it is culpable homicide not amounting to murder, then first degree or second degree.
Because they have not taken him immediately to the hospital. Had that been done, possibly there may be a possibility. They went to the police station, police came. So in this process, more situation had even worsened.
Thirdly. And then thirdly. This appeals. Yes. So what is your submission? Murder,
Yes.
culpable homicide amounting to murder. But it is not that from the father who is saying that the deceased was not unarmed.
Yes, sir. You know, from the
He
piece
was
of
something, he had something in his hand.
Yes. From the piece
According
of
to
PW2.
PW2.
Oh.
So PW2 is, say, somewhat related in same degree
Yes,
to
sir.
the accused and the deceased.
Yes.
The deceased was his son-in-law,
Yes.
the accused was his son. So what do you say about this?
So, from the face of the record of the PW1, this is the eyewitness lordships.
We are on the
Yes.
issue. Culpable homicide,
Yes, sir.
murder,
Yes.
and culpable homicide not amounting to murder. What do you say about this?
It is a murder lordships. Because from the face of the record, it is apparent that the accused went to the.
There was a fight in the morning.
Yes, lordships.
So it had a tendency
Yes, lordships.
of repetition,
Yes, lordships.
and it had happened in the evening also, right?
The accused went
He
to
might
the.
be inimically disposed, the accused might be inimically disposed towards the deceased, but it was repeated. Then there are two acts attributed to PW2.
Yes.
See, there was an iron pipe in the hand of my son-in-law.
Yes.
And next, one more. That when I went to resist my son-in-law, he pushed me down. So there is another aggressive part.
From the side of the deceased.
Disease.
Yes.
So it might be a fight.
Yes.
And it was the disease who got the first opportunity to accused to assault, which prevented the diseased might be to retaliate. So the accused got the first opportunity.
Yes.
Disease did not get the opportunity to retaliate because already there is a stabbing in his chest. So it could be a case of culpable homicide not amounting to murder of the first degree. Already he is there. We'll proceed like that. It would be- Uh, This appeal from jail. Under section 383 Code of Criminal Procedure is directed against a judgment and order dated 2/7/2015 passed by the Court of Learned Additional Session Judge bracket FTC Lakhimpur at North Lakhimpur in sessions case number 184 within bracket NL stroke 2014. Full stop. By the judgments and order dated 2/7/2015, comma, the accused appellant has been convicted for the offense of murder defined in section 300 of the Indian Penal Code. And he has been sentenced under section 302 IPC to undergo rigorous imprisonment for life and to pay a fine of rupees 5,000, in default of payment of fine, to undergo rigorous imprisonment for another 3 months. Full stop. Para. The investigation was initiated on the basis of a first information report instituted by the informant, Musammat Ombia Khatun before the officer in charge, Bipuria Police Station, on 10/1/2014. Full stop. In the FIR, the informant has alleged that at around 6:30 p.m. on that day itself, that is on 10/1/2014, the accused named therein, who is the brother of the, who is and brother of the informant, killed her husband, Mobin, Moubin, inside the house, inside her house, inside their house, by stabbing with a dagger. Full stop. On receipt of the FIR, the officer in charge, Bipuria Police Station, registered the same as Bipuria Police Station case number 11/2014 for the offense under section 302 IPC and initiated investigation. Full stop. Para. During the course of investigation, Commander IO, the investigating officer IO, recorded the statements of a number of witnesses under section 161 CRPC, semicolon, visited the place of occurrence, and also visited the place of occurrence, that is the house of the informant. Full stop. The inquest on the dead body of the deceased was held and thereafter, the dead body was forwarded to the North Lakhimpur Civil Hospital for post-mortem examination. The post-mortem examination of dead body of the deceased was performed Civil Hospital on 10/1/2014. Post op. In the course of investigation, the IO had seized the alleged weapon of assault by the seizure list, MR number 01/2014 on 11/1/2014 on being allegedly shown by the accused, in presence of witnesses, full stop, after completing investigation into the case, B. Puria Police Station case number so-and-so, the IO of the case submitted a charge sheet under section 173(2) CRPC, finding a prima facie case well established against the accused for the offense of murder under section 302 IPC. Right. Charge sheet number 147/2014 on 38/2014. Okay, we'll resume. Last line to mind. On submission of charge sheet, the Court of Learned Judicial Magistrate First Class Lakhimpur caused production of the accused from judicial custody on 27/10/2014. So as the copies were ready, the same were furnished to the accused following the procedure laid down in section 207 CRPC. Full stop. As the offense under section 302 exclusively tribal by a court of session, the Learned Judicial Magistrate First Class Lakhimpur committed the case records of ZR case number 55/2014 to the Court of Sessions, not Lakhimpur. Court of Sessions, Lakhimpur over there? Lakhimpur. By an order of commitment dated 27/10/2014. Post up. On receipt of the case records of ZR case number so-and-so, the Court of Sessions registered the same as Sessions case number 184 stroke within bracket NL stroke 2014. Full stop. Thereafter, comma. Case was transferred to the Court of Additional Sessions FTC Lakhimpur for trial and disposal. Okay, trial court. Post upon appearance of the accused before the learned trial court and after hearing the learned public prosecutor and the learned defense counsel, and upon perusal of the materials available in the case records, comma, the learned trial court on 18/8/12/2014, comma, frame the following charge. Page 6. When the charge was read over and explained to the accused, comma, he pleaded not guilty and claimed to be tried. Full stop. During the course of the trial, comma, the prosecution side evidence through 7 number of prosecution witnesses and exhibited documentary evidence through 7 exhibits. Full stop. After closure of the prosecution, evidence from the prosecution side, comma, the accused was examined under section 313 CRPC by putting before him the incriminating circumstances appearing from the evidence led by the prosecution. Full stop. When the accused was asked as to whether he would adduce evidence in defense, comma, he answered in the affirmative. Full stop. However, comma, did not adduce any defense evidence. Full stop. After hearing the learned counsel for the parties and after appreciation of the evidence stroke materials on record, comma, the learned trial court, finding him guilty for the offense for the charge of murder under section 302 CRPC, has convicted him and the accused is accordingly sentenced in the manner, comma, mentioned above, indicated above. Full stop. Para, we have heard MSB Sharma, learned amicus curiae, appearing for the accused appellant, and Mr. KK, semicolon, Mr. KK Das, learned additional public prosecutor for the respondent number 1, comma, state of Assam, and Mr. P. Dotto, learned respondent number 2, test informant. Full stop.
Pro bono আছে এখানে। Pro bono।
It's a program.
Counsel who has appeared as pro bono counsel for the respondent number 2, test informant. Para. MS Sharma, learned amicus curiae, has submitted that out of the non-official prosecution witnesses, the testimonies of PW1 and PW2 are of relevance and significance, as they were the only witnesses who seem to be present in the vicinity of the place of occurrence at the relevant time. To stop. It is contended by MS Sharma that both the witnesses, PW1 and PW2 seem to be related and interested witnesses. And as such, to stop as such, and as such, their testimonies need evaluation with caution. Full stop. It is further submitted that the recovery of the alleged weapon of assault is also doubtful. Full stop. Submitting further, learned amicus curiae has submitted that the charge was only with regard to a single blow. Full stop. It has emerged from the testimony of PW2 that the deceased was also was not unarmed at the relevant point of time. Full stop. It has it is contended that from the evidence on record, it can be inferred that the alleged assault was not unilateral. Full stop. As there were in discrepancies on several points, the accused is entitled to the benefit of doubt. Full stop. Contending so, NDPS has submitted that the impugned judgment and order of conviction and sentence passed against the accused is liable to be interfered with. Full stop. Para Mr. Das, learned additional public prosecutor, has supported the judgment and order of conviction and sentence passed against the accused on the premise that there were no apparent inconsistencies in the testimonies of the two vital witnesses. Full stop. uh, that is, comma, PW1 and PW2, full stop. The said two prosecution witnesses were related both to the deceased and the accused. And as such, comma, they cannot be said as interested witnesses and related witnesses at the same time. Full stop. It is a submission that the presence of these two witnesses at the relevant point of time at the place of occurrence was natural. Full stop. In absence of any other evidence to the contrary, comma, it is clearly established that it was the accused only who had assaulted the deceased. Full stop. The matter of recovery of the alleged weapon of assault was not challenged by the accused during the course of trial in any manner whatsoever. Full stop. When the incriminating circumstance regarding recovery of the alleged weapon of assault, comma, the dagger was put to the accused during his examination under Section 313 CRPC. The accused did not offer any plausible explanation. Full stop. As the prosecution has been able to lead evidence beyond all reasonable doubts, comma, the judgment and order of conviction and sentence does not needs no interference. Meaning thereby, comma, the appeal is bereft of any merits. Full stop. Para Mr. Dr. Learned Counsel, who has appeared pro bono on behalf of the respondent number 2, that's informant, has submitted that there is nothing in the evidence wherefrom an inference can be drawn that the informant wife had implicated her own elder brother on false accusation. Full stop. He has adopted the submissions advanced by the learned additional public prosecutor on behalf of the state. Full stop. Anything more? Full stop. We have given our due consideration to the submissions advanced by the learned counsel for the parties and have also gone through the evidence stock materials including the testimonies of the prosecution witnesses and the documentary evidence, comma, available in the case records of sessions case number so and so, comma, in original. Full stop. Para. Out of the prosecution witnesses, having heard the learned counsel for the parties, comma, it has emerged that out of the prosecution witnesses, the testimonies of the sorry, the evidence of the informant as PW1 is of vital import and significance, as C was one of the two witnesses who were present at the relevant time in the vicinity of the place of occurrence. Full stop. The place of occurrence is the house of the father, within bracket, PW2 of the informant as well as the accused, right? Para. In her evidence in chief, comma, PW1 stated that the accused is her own elder brother. And the FIR within bracket EXT1 was lodged by her against the accused. Full stop. As regards the incident, comma, PW1 deposed to the effect that the incident took place at around 5:30 p.m. on 10/1/2014 on the road behind their house. Full stop. PW1 stated that there was a prior incident on that day, as in the morning hours on that day, comma, the accused assaulted her husband, full stop. Though she got an azahar written as regards the said incident of assault, comma, she did not lodge the same at the police station. Full stop. In the evening hours, comma, the accused came to the room where the informant and her husband used to live. Full stop. The room was situated in front of her parental house. Full stop. When she saw her elder brother, comma, she made a query to him as to why he assaulted her husband in the morning. Full stop. In response, comma, the accused chased her in order to assault. Full stop. When she raised hue and cry, as she fell down, She raised hue and cry. Full stop. Then the accused ran away from there, and on the way, he met her husband. Stop. Then the accused assaulted her husband with a dagger. Full stop. Witnessing the scene, she ran towards her husband. Full stop. She saw the accused and her husband standing face to face. Full stop. Seeing her, the accused left the place. Full stop. Then, she held her husband as he was about to fall on the ground. Full stop. She noticed that blood was oozing out from the chest of her husband. Full stop. She started screaming, thinking that her husband was dead, she started screaming. Full stop. Hearing her screaming, her father, within bracket, PW2, came near her and held her husband. Full stop. Her father, PW2, also raised alarm. Full stop. Then, she, leaving her husband with her father, PW2, bracket, she went to the police station. Full stop. She was already, her wearing apparels were already stained with blood from the injury, flowing out of the injury of her husband. Full stop. PW1 further stated that her husband was taken to a hospital at Bipuria by a 108 ambulance from the police station. Full stop. But her husband breathed her last in the meantime. Full stop. During cross-examination, PW1 stated that her elder brother, that is the accused, used to live separately, whereas she used to live with her father, within bracket PW2. Full stop. As she stated, as PW1 stated, during her evidence in chief, no, it is, no, PW2, 1, stated that the marriage, she got married after a love affair, and the accused did not accept the marriage. PW1 further stated that her father's land was yet to be divided. As regards the as regards her husband, PW1 stated that he was a driver in Saudi Arabia. Full stop. After their marriage on 3/9/2011, he went to his workplace only once. Full stop. Later on, after returning from Saudi Arabia, he did not return. Full stop. Narrating about the earlier incident, PW1 stated that it was at around 8 a.m. The accused assaulted her husband. Full stop. She stated that she saw the dagger at the time of taking it out, and it was stained with blood. Full stop. Para. PW2. Yes. PW2, the father of the accused and the informant, and the father-in-law of the deceased, corroborated the testimony of PW2 1 by deposing that it was at around 6/6:30 p.m. on 10/1/2014 the incident had occurred. He stated that he was in home at that time. Hearing hue and cry from the direction of the road beside the house, he came out and saw that the accused and his son, the accused, and his son-in-law, the deceased, were entering the backside of the house through a narrow path. Then he also went to the backside. He saw an iron pipe in the hand of his son-in-law with the accused. Also there. This backside is backside of the house,
Backside of the house.
not behind the DG. Full stop. Seeing then he went forward to resist his son-in-law, but he was pushed down. Full stop. PW2 testified about the presence of his daughter, that is the informant, with him at the place of occurrence. Full stop. PW2 had seen the informant holding her husband and heard us screaming that a murder was committed. Full stop. He also corroborated the testimony of PW1 by testifying that holding his son-in-law, who became unconscious, he sat down on the ground and sent her daughter, that is the informant, to the police station. Full stop. PW1 also deposed about the ambulance and presence of police personnel at the place of occurrence with his daughter. Full stop. He also stated about taking the his son-in-law, injured son-in-law to the hospital. Full stop. He testified that he saw his son, the accused, and his son-in-law, the deceased, entering into the narrow path. And at the time, he did not see presence of any other person. Full stop. When cross-examined, PW2 stated that there was darkness at the time of incident. Full stop. He stated that at the time of incident, only he, his daughter, and his son-in-law were present in the house. Full stop. He had, however, stated that he did not see committing the murder. Full stop. It was his daughter who stated to him that the murder was committed. Full stop. PW3 is a son of PW2. Full stop. He is a younger brother of the accused and an elder brother of the informant. Full stop. PW3 stated that when the incident took place in the evening hours of 10/1/2014, he was not present as he went to work. Full stop. He has corroborated the version of the informant, PW1, to the extent that in the morning hours on 10/1/2014, a quarrel took place between his elder brother, that is the accused, and his brother-in-law, that is the deceased. Full stop. Before he left home for work, he told both of them not to fight. Full stop. Later on, after coming back from home from work, he saw gathering in the house. Full stop. When he asked the informant, finding her crying, it was told to him that the accused had killed the deceased. Accused had killed her husband. Full stop. In cross-examination, PW3 stated that, reiterated that he did not see the occurrence. Full stop. From the testimonies of the aforementioned three prosecution witnesses, it is demonstrated that the occurrence, the deceased was assaulted inside the premises, inside the house premises of PW2, where the informant, her husband, and her father used to reside. Full stop. Where he reside? Accused?
Same campus.
Full stop. The accused also used to reside in the same house premises. Full stop. Though the accused being closely related to these three prosecution witnesses, to the prosecution witnesses, PW1 and PW2, his identification was not in doubt, though the occurrence took place in the evening hours. Full stop. PW1 was categorical in her testimony that she saw the dagger when it was being, she saw the blood-stained dagger when it was being taken out. Full stop. She had also categorically stated that the injury was on the chest of her husband and blood was oozing out of that injury, full stop, as a result of the assault, her husband fell down on the ground, was about to fall down on the ground. At that time, she held her husband. Full stop. Then, full stop. As her father, PW1, was also present at the place of occurrence at that time, he then held the injured, who became unconscious in the meantime. Full stop. Para. It is from the defense. It is not the case of the defense. No, sorry. The accused during sorry. The testimony of the prosecution of the two prosecution witnesses, PW1 and PW2, to the effect that the accused was present at the place of occurrence, was not challenged in any manner by the accused. Meaning thereby, the testimony of these two witnesses on that point was not second, SHAKEM, full stop. Para. When in the backdrop of such testimony of PW1 and PW2, the medical evidence, which is laid by the prosecution to the testimony of the autopsy doctor, PW W5 and the findings recorded in the PME report EXE3 are examined, the medical evidence is found to have corroborated the ocular testimony of PW1 and PW2. Full stop. The dead body, the postmortem examination on the dead body of the deceased was performed at North Lakhimpur Civil Hospital at around 2 p.m. on 10/1/2014 by PW5, who was serving as the medical and health officer, -1
Senior.
senior.
Page number 16.
They call it heavily medical. Oh,
For designation.
okay. Medical and health officer, -1, North Lakhimpur Civil Hospital. Full stop.
সি যেতিয়া কোৰ্টত সাক্ষী দিলে তেতিয়া চিনিয়ৰ মেডিকেল অফিচাৰ হৈছে এক্সামিনেশ্যন টাইম MNHO 1 আছে
he, in his testimony, PW5 stated that he found a lacerated injury over the left side of the chest. Lacerated injury of 2 inches over the nipple of the left side of the chest. And after performing, full stop, he opined that the injury, all the injuries suffered by the disease were antemortem in nature. Full stop. He deposed that, in his opinion, recorded in the postmortem exam PME report EXC3, he reported that the cause of death was due to stab injury to major pulmonary vessels, which caused massive intrapleural hemorrhage. Page 17. The autopsy doctor, within bracket PW5, was found to have was not waiting for recording was not cross-examined by the defense. Post op. কি করেছে? Oh. In cross-examination, PW5 stated that he found the stab within bracket left side injury. Now, he found that the stab within bracket left side injury was above the nipple of the deceased. In the PME report, PW3, the findings were recorded as under and Dhagdias. Dhagdias. Pera. As regards the alleged weapon of assault, it is a case of the prosecution that the weapon of assault was a knife of about 9 inches approx long. PME report. In the PME report, the autopsy doctor PW5 had further opined that the time of death was about 15 to 16 hours earlier. Such time of death seem to have matched with the time of occurrence of assault, as testified by PW1 and PW2. In this connection, and it is found in this connection, it is found that the IO in bracket PW search. In the course of examination, in the course of investigation, had conducted inquest on the dead body of the deceased at Bipuria, PHC, through a circle officer, through the circle officer, Bipuria Revenue Circle, on 10/1/2014, before sending the dead body for post-mortem examination.
8 p.m. 8 p.m.
At 8 p.m. on 10/1/2014, before sending the dead body for post-mortem examination, full stop. In the inquest report, exhibited as EXT5, it was reported that there was stabbing by knife on the left chest, on the dead body. Full stop. PW2, was a witness to the inquest report, within bracket EXT 5. Full stop. The findings in the inquest report EXT5 consistent with the findings recorded in the PME report EXT3 and the ocular testimony of PW1 and PW2. Full stop. Para. Weapon of assault, no? Weapon of assault. PW 4. Testified to the effect that having heard that the accused had killed his brother-in-law with a knife, he went to the place of occurrence and saw the injury on the chest of the injured, knife injury on the chest of the deceased. Full stop. He further testified that when police personnel, after arrival of the police personnel, the accused himself showed the knife, which was used in the incident. Full stop. He further stated that the knife was seized by the police personnel in his presence while seizure list, while the seizure list, EXT2, wherein he subscribed his signature as EXT21. Full stop. PW2 was, however, not confronted by the defense on the point of such seizure in any manner whatsoever. Full stop. This part of the testimony of PW4 found corroboration in the testimony of the IO PW7, who stated that he and he taking the accused along with him, accused along, went to when near when near went to ward number near Magic Stand, near a place, went to a place near Magic Stand, ward number 8, Bipuria town. and full stop. At the said place, comma, he recovered the knife. He recovered a knife, comma, as shown by the accused. Full stop. He then drew a sketch map of the place of the PO within bracket EXT 7. Under his signature, EXT 7 1. Full stop. The IO PW 7 exhibited the serial list as EXT 2. Exhibited the sketchmate of the PO of seizure of knife as EXT 1 and the seizure list whereby the knife was seized, comma, as EXT 2 and his signatures therein, full stop. PW 4 was one of the seizure witnesses of the seizure list EXT 2. Full stop. The defense was not successful in eliciting anything contrary by cross-examining the IOPW 7, full stop. When the IOPW 7 was cross-examined, he stated that knife, as shown by the accused, was recovered in a culvert located between the Magic within bracket vehicle stand and Hanuman Mandir in Bipuria town. Full stop. Fair. On evaluation of the on close evaluation, on close scrutiny and evaluation of the evidence, above evidence laid by the prosecution, it has clearly emerged that the death of the deceased on 10/1/2014 was caused due to the assault made in the vital part of the body, that is, 2 inches above the nipple on the lips, chest. Full stop. As a result of the injury, which was a stab injury, major pulmonary vessels just sorry, as a result of the injury, comma, which was a stab injury, comma, on or on two major pulmonary vessels. There was massive intrapleural hemorrhage. Full stop. As a result of the injury, comma, the left lung of the disease was fully covered with blood of about 3 liters, and the right side of the heart was full of dark fluid blood, while the left side became empty. The death of the deceased was clearly a homicidal death. Full stop. From the evidence testimony of PW1 and PW2, who were found to be consistent throughout, comma, it can be safely the finding can it is clear that it was the accused who had caused, who had inflicted the blow on the deceased. Full stop. Para. It's not judgment case.
Exception. Statement of
Penal code, comma, quote, culpable homicide, unquote, is genus and murder, quote unquote. It's specie, full stop. All murder is culpable homicide and not vice versa. Full stop. Culpable homicide, sense special characteristic of murder is culpable homicide not amounting to murder. Full stop. In State of Andhra Pradesh versus Rayabharapu Punaiyak and another, comma, reported in 1976 for SCC 382, comma, it has been explained that for the purpose of fixing punishment, comma, proportionate to the gravity of this of the generic offense, comma, the code practically recognizes 3 degrees of culpable homicide. To stop. Para 12 process, silo 142. The first is, comma, what may be called, comma, quote unquote, culpable homicide of the first degree. Full stop. This is the greatest form of culpable homicide, comma, which is defined in section 300 as murder. Full stop. The second may be termed as culpable homicide of the second degree. Full stop. This is punishable under the first part of section 304. Full stop. Then there is culpable homicide of the third degree. Full stop. This is the lowest type of culpable homicide, and the punishment provided for it, comma, is also the lowest amongst the punishments provided for the 3 grades. Full stop. Culpable homicide of this degree is punishable under the second part of section 304. Full stop. It has been explained further that when a court is required to answer the question whether the offense is murder or culpable homicide not amounting to murder, comma, on the facts of a case, comma, it will be convenient to approach the problem in 3 stages. তাৰপিছত এইখিনি ক'লোতো পেৰা 21 যিটো আছে পেৰা 21 ফাৰ্ষ্ট ব্ৰেকেট যিটো দিয়া আছে ফাৰ্ষ্ট ব্ৰেকেট ফাৰ্ষ্ট ব্ৰেকেট হেৰি কৰক A2A কৰি দিয়ক A2A হ'ল IPC from clause thirdly of section 300 IPC in clause thirdly in clause third it has been set forth that culpable homicide is murder if it is done with the intention of causing bodily injury to any person, and a bodily injury intended to be inflicted is sufficient in the ordinary course of nature to cause death. Full stop. The situation has been explained further in illustration C there too, comma, which raises under. In Virsa Singh versus State of Punjab, comma, reported in 1958 SC 465, comma. Clause thirdly of section 300, comma, IPC has been explained, has been elucidated in the following manner. B2B, এটাতে পুনः পাতে আছে। from the above exposition, comma, and the rule laid down in Birsa Singh, comma, even if the intention of accused was limited to the infliction of a bodily injury sufficient to cause death in the ordinary course of nature and did not extend to the intention of causing death, comma, the offense would be murder. And illustration C appended to section 300 has clearly brought out the said point. Full stop. Para. As full stop. Punappa. After reaching a finding that the offense here comes within the scope and ambit of clause 30 of section 300 IPC. That is, comma, murder. What needs an examination is whether the facts and circumstances obtaining the case brings it within one of the exceptions to section 300, comma, IPC. Closed. It was 2003, 9 is 2003. Para 2003, 9 SSC, 322, underline, yeah, underline. The whether a case comes within the exception 4 of section 300 IPC or not was considered in Dhiraj Bhai, Gorak Bhai Nayak versus State of Gujarat, comma, reported in 2003, 9 SSC 322. Full stop. Deliberating on fourth exception of section 300 IPC. Comma, it has been observed that exception 4 deals with cases in which, notwithstanding that a blow may have been struck, comma, or some provocation given in the origin of the dispute, or in whatever way the quarrel may have originated, comma, yet the subsequent conduct of both parties puts them in respect of guilt upon an equal footing. Full stop. This sudden fight implies mutual provocation and blows on each side. Full stop. The homicide committed is then clearly not traceable to unilateral provocation. Nor could in such cases the whole blame be placed on one side. Full stop. A fight suddenly takes place, comma, for which both parties are more or less to be blamed. Full stop. It may be that one of them starts it, comma, but if the other had not aggravated it by his own conduct, it would not have taken the serious turn it did. Full stop. There is then mutual provocation and aggravation, comma, and it is difficult to apportion the share of blame which attaches to each fighter. Full stop. The help of exception 4 can be invoked if death is caused A, without premeditation, B, in a sudden fight, C, without the offender having taken undue advantage or acted in a cruel or unusual manner, and D, the fight must have been with the person killed. Full stop. It has been noted that the quote unquote fight occurring in exception 4 to section 300 IPC is not defined in IPC. Full stop. It has, however, observed that it takes two, 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 to make a fight. Full stop. Heat of passion requires that there must be no time for the patients to cool down, and in this case, comma, the parties had worked themselves into a fury on account of the verbal altercation in the beginning. Full stop. A fight is a combat between two and more persons, whether with or without weapons. Full stop. It is possible to enunciate, it is not possible to enunciate any general rule as to what shall be deemed to be sudden quarrel. Full stop. It is a question of fact, and whether a quarrel is sudden or not must necessarily depend upon the proved facts of each case. Full stop. For the application of exception 4, comma, it is not sufficient to show that there was a sudden quarrel and there was no premeditation. Full stop. It must further be shown that the offender has not taken undue advantage or acted in a cruel or unusual manner. Full stop. The expression, quote unquote, undue advantage as used in the provision means unfair advantage. Full stop. Para 11. On the facts and circumstances, from the facts and circumstances of the case in hand, facts and circumstances obtaining the case in hand, comma, it has emerged that there was a quarrel between the accused and the deceased in the morning hours on the date of the incident. Full stop. From the testimony of PW3, comma, it has emerged that he finding that there was a quarrel between the accused and the deceased in the morning hours on the date of occurrence, day of occurrence, comma, told them before he's leaving for work, told both of them before he's leaving for work, comma, not to fight. Full stop. The caution given by PW 3 to both the accused and the deceased is suggestive of a quarrel which was not unilateral. Full stop. It is also suggestive of the fact that the quarrel which took place in the evening hours, it is suggestive of the fact that the incident of assault was a continuation of the quarrel which took place in the morning on the relevant date. Meaning, full stop, does, comma, the quarrel in the morning was a precursor to the incident occurred in the evening on the relevant day. Full stop. From the testimony of PW2, comma, it had emerged that at the time of the incident, comma, the disease was also not unarmed, as PW2 testified that at the time of occurrence, comma, the disease was holding an iron pipe in his hands. Full stop. From the testimony of PW further, from the testimony of PW2, well, no, PW2 further testified that when he went to resist the disease, comma, he was pushed down. Full stop. Such situation was suggestive of a of an aggressive attitude, pushing or aggressive. Aggressive.
Silo.
Huh?
So silo.
Oh. Suggestive of an aggressive posture, posture, also on the part of the diseased. Full stop. The situation. Oh, packet to direction, packet to. ডাঙৰটো 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 নহয় ডাঙৰ ইটো টাইপ কৰা At the time of occurrence, the accused was also who is a resident of the same premises as like the deceased, was in home. Full stop. The weapon of assault, a dagger of the kind mentioned, seized by the prosecution, is not is one which is ordinarily available in the 9 inches means what? This much. Which is ordinarily found available in a house in the weapon area, or house in the in a village, in every household, in a village. Full stop. Does the nature of weapon used is not one of exception. Full stop. The incident from the testimony of PW1, it has emerged that the intention of the accused was, it has emerged that when the accused was chasing the informant, he confronted with the deceased on the way, and the fight ensued thereafter. And in the fight, that which ensued, it was the accused first who had made the assault on the deceased, on the vital part of the on the body of the deceased. And the deceased, who was also armed with an iron rod, did not have the opportunity to retaliate. Full stop. Thus, in such facts, obtaining facts and circumstances, full stop. After giving the blow, single blow, the accused did not restrain himself, did not make any further assault on the deceased as he fell down, as he was about to fall down. Full stop. Leaving the deceased in that stage, the accused left the place of occurrence. Full stop. In such obtaining facts and circumstances, or the case appears to be one which is committed without meditation, and it was an act which emanated in a sudden fight in the heat of passion, upon a sudden quarrel, and without the accused having taken unfair, undue advantage or acting in a cruel or unusual manner. Full stop. Para. Thus, for the from the above discussion and the reasons assigned therein, we have the considered view that the offense committed by the accused is not murder within the scope, or no, is oh my God.
Out of first degree or second degree?
If you correct to go. Yes. Not of the greatest form of culpable homicide, which is defined in section 300, IPC. Full stop. It is a case of culpable homicide of the second degree, punishable under the first part of section 300, IPC. Full stop. Therefore, sitting 304, first part of 304. 304 question? 303 and or 304. First part of 304. Full stop. Therefore, the judgment and order dated so and so of conviction and sentence passed by the learned trial court. Insofar as under section 302 IPC is set aside and the same is altered to part 1, section 304 IPC. Full stop. It has been submitted at the bar that since the date of his initial arrest, the accused appellant is in custody till date. Full stop. Having regard to the provisions contained in part 1, section 304 IPC, we are of the view that the periods, you say 10.
10 years, 5 months exactly.
Have submission to record.
Learned NDPS query has submitted that the period of incarceration of the accused appellant is more than 10 years,
5 months.
5 months.
10-1, 10-1, 14.
Tell me, we are recording, we are not calculating. We are not calculating, we are depending on you.
Yes, Lordship, what I found from the record that he's all along in jail from the
So,
record.
according to you, what? More than 10 years. 10 years, 5 months.
10 years, 5
Is
months.
about 10 years, 5 months
Yes, Lordship.
till date.
Date of incident is 10-1, 14. So today
Oh,
11.
You go through, calculate.
No, that is today we are on 11-6. So 10-1. From 10-1 to
You calculate, I'll not exercise my.
10 years, 5 months. 10 years, 5 months.
From 11-1-2014, he was produced before the court.
Yes.
So 11 what? It will be,
Today is 11-6.
So since the date of the initial arrest on 11/1/14.
14.
Having regard to the P04 part কিমান দিয়ে বা কিমান আছে 304 part imprisonment may extend to 10 years. Imprisonment for the ends of justice will be subserved in converting the sentence of the accused to the period already undergone by him. So it is accordingly observed. Stop. As stop, the petitioner accused appellant is to be released from the custody forthwith, if his detention is not required in any connection with any other case. Stop. Resultantly, the instant criminal appeal stands partly allowed to the extent indicated above. Appreciation B. Sharma and P. Dotto. Pro bono, amicus and pro bono. The case records of the trial court be sent back.
Compensation কথাটো এটা নাই।
আছে নেকি কিবা? তাৰ আগত এই compensation to review. Compensation extent victim compensation scheme framed under extant, 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 framed under 357 ACMs. But don't expect his release today. We have to correct it.
May I point out one thing, Lordship?
Huh?
The accused was living separately, not in the same premises.
Not separate.
Separate.
Where from?
From the cross-examination PW1, Lordship.
Cross-examination of
House is
PW.
separate.
Yes, Lordship. Wherever he lives separately. Lordship.
Live separately, but it is,
Not-
I think,
Because
same
land
premise.
is not
That
divided.
is the-
There are
Yes,
houses.
yes.
If you see the sketch map,
Yes,
yes, anything. My brother has a single means.
And I beg to mention item number 9, man.
Yes.
After long
that-
pursuing, I ultimately managed to get the list matter listed today.
Ah.
Okay, may I, my lord, pray for listing of fixing the matter, my lord, on 25th, my lord?
We'll not say 25th in the next week. In the
Next week, again, they will not, my lord, because
No, no, in the next week means not after a week. In the next week means next week. On a date according to the, it is 9 today. So it did not reach. Okay, on the, as sought for by Mr. Alhazi Uddin,
yeah, you think.
learned counsel for the appellants. And as agreed to by the learned MS SH Bora, learned additional public prosecutor for the respondent state, list the appeal in the next week. On a date to be fixed by the office. Yes,
number 7, Lordship. But
Yeah.
that may be fixed, Lordship. The date may be fixed, Lordship. It's a permanent alimony case and it's lingering for a long time, Lordship.
maybe 22, not long time. The appeals are from 2017 to 19. So that submission is not very in the same pedestal as criminal appeals.
I'm submitting on the basis of like, there are lots of adjournments taken, maybe 10
No,
times.
maybe after vacation, you get a date, fix a date,
No, not this month, Lordship.
not this month.
So,
We have already fixed many matters
after
for
vacation,
disposal.
Lordship. After vacation, Lordship, 25th of July, Lordship.
Okay, on the prayer of Mr. You are for the respondent.
Respondent.
Okay, any petitioner? Yes, madam, you are for the petitioner. Okay, Miss
And Kolita.
and
And Kolita.
Colita, learned counsel for the appellant, and Mr. Ndeka, learned counsel for the respondent, are present as sought for by the learned counsel for the parties, lays the case on 25/7.
5th of July.
Yes.
Lordship, for item 8 in the matter, come up after vacation, Lordship. I've already.
You made a prayer. Okay.
Yeah, in the morning I made a prayer, but. Yes,
You
sir.
are reiterating your prayer.
No, Lordship, I made a prayer in the morning, but it was
Yes.
declined because I did not
Okay.
take consent from the opposite party, but I have.
Let
taken
it be
the-
left over.
Okay, Lordship.
With the consent of the, my lord, with the consent of the respondent, my lord, item 10, 11, 12. It's an NIA matter, my lord. So bail matter, my lord, listed on
How
Thursday.
many? Period of detention?
My lord, more than 7.
Only 7.
No, my lord, 700 to approach, my lord, 700.
7.
Yes, my lord,
There are appeals 5 to 10 years.
my lord. On
Next week?
Thursday, my lord.
After week? No, we will fix. After. Thursday. Gimana susah? List kan sound fix. Tomorrow is there is a appeal. Of course, you are it was, no? This is circumstantially very. This. This.
Next week Thursday.
Possible নহয়। Oh, sorry. No.
You can put it on 26.
26.
You can make a try. Other dates are fixed already.
Well,
লিখক, Mr. N. Bormon and Mr. D. Bharadwaj,
Respondent to.
NIA. Release the cases on 26.
deeply obliged.